Can I be a whistleblower if I participated in the scheme and or fraud? A lot of whistleblowers may have somewhat unclean hands. At the FBI, we used to say big sources, big problems, mid sources, mid problems, no sources, no problems. However, without sources, you can't make big cases. And when there's fraud going on, to make a big case, you sometimes need someone whose hands are a little dirty, or at minimum, know where the dirt is. That's why you need an objective whistleblower lawyer right away who can tell you if the dirt just won't wash off, or with a little rinse and refresh, whether you'll be eligible for a whistleblower award. The dirt could be anywhere and everywhere. Some dirt involves people who process claims. Some entered diagnosis codes, signed off on reports. Some prepared invoices, helped with tax schedules, helped with invoices for customs, cleared compliance alerts. Some were just following orders from a supervisor, and a lot of people were just following orders, and only later realized that the company may be committing fraud. So the question is, can I still be a whistleblower if I participated in the fraud? The answer is, most of the time, yes, but you gotta watch out. Once your own conduct could be questioned, the strategy has to change immediately, not to advancing the ball for an award, but to protection. It's not a situation where you just fill out a form, call a regulator, or confront your employer. What you really need to know is, number one, what's the upside for you? But before that, what's the exposure for you? And here are 4 questions to ask. First, what did you actually do? Second, what did you know? Third, when did you know it? Fourth, what whistleblower program applies? And as always, follow the dough. The government will want to know, did you receive money as a result of the fraud? And if so, how much? The False Claims Act, SEC, IRS, CFTC, and AML programs do not treat participation in the same way. Let's start with the False Claims Act. The False Claims Act is used to remedy fraud against the government, whether it's Medicare fraud, Medicaid fraud, defense contractor fraud, government procurement fraud, cybersecurity certification fraud, PPP fraud, grant fraud, customs fraud, or other false claims involving federal government money. Under the FCA, being involved does not automatically prohibit you from obtaining a whistleblower award. But the statute does address people who planned and initiated the fraud. If the court and or the DOJ find that the relator planned and initiated the violation, you may have a whistleblower reward reduced. If the relator/whistleblower is convicted of criminal conduct arising from the violation, the relator is dismissed from the civil action and receives nothing. That means participation is not just one thing. Participation may have multiple meanings, and you need to sort that out early. For example, a billing clerk who followed instructions is not the same as an executive who designed and profited handsomely from the scheme. A coder who later realized diagnoses were unsupported is not the same as a person who ordered the manipulation and was paid per claim. A salesperson pressured to follow a script is not the same as the person who wrote the fraudulent script and directly economically benefits from it. The key is to separate casual, passive, or even active involvement from leadership and direct profit per scheme under the False Claims Act. Now let's look to see whether you're eligible for an SEC whistleblower award if you're part of the scheme. SEC cases can involve public company fraud, accounting manipulation, misleading investor disclosures, insider trading, market manipulation, crypto fraud, FCPA issues, Ponzi schemes, and investment advisor misconduct. The SEC rules consider culpability when determining awards. Culpability can reduce the award. So can unreasonable delays and interference with internal compliance systems. And SEC whistleblower status is not immunity. If you violated the securities law, becoming a whistleblower does not automatically protect you from SEC action. This is a critical point. A whistleblower submission is not an immunity agreement. Now we're going to look at whether or not you're eligible for an IRS whistleblower award if you participate in that scheme. IRS cases are submitted through Form 211. They may involve offshore accounts, hidden income, sham deductions, abusive tax shelters, payroll tax fraud, transfer pricing manipulation, crypto concealment, tax underpayments, or any of 1,000 ways people deprive the federal government of money wrongfully when they're owed taxes. The IRS has its own version of the same issue. Did the whistleblower plan and initiate the action that led to the underpayment? If so, the award can be reduced. If the person is convicted of criminal conduct arising from their role, the award can be denied. That's a common theme in all these programs. But IRS guidance also draws a meaningful line. A junior employee acting under the direction and control of a senior employee is not the same as someone who designed or launched the tax scheme. So the extent of the role in the tax scheme is very important to flush out to determine, number one, eligibility for the award, and number two, whether or not there's criminal exposure. CFTC and AML cases have similar themes to see if people are eligible for awards if they're committing some of the conduct. The CFTC rules consider culpability, scienter, financial benefit, delay, and interference with compliance systems. FinCEN and AML cases can involve transaction monitoring, sanction steering, KYC, SAR decisions, suspicious transfers, shell companies, and money laundering. If you participate in clearing alerts or approving the transactions, that does not automatically mean you don't have a whistleblower path, but it does mean your role must be evaluated before you report. Now, I want to talk about something that applies to all the programs. Immunity. A lot of people think if I blow the whistle, I receive immunity. That's just wrong. A whistleblower reward track and a criminal cooperation agreement and track are just two different things. The reward track is about voluntarily providing original useful information that leads to a successful enforcement action. The Protection Act may involve a proffer, cooperation presentation, voluntary self-disclosure, non-prosecution discussion, or some sort of criminal defense strategy that you're providing information so you won't go to jail. These tracks can overlap, but they're definitely not the same. And sometimes they conflict. If you're seeking immunity or leniency because you're afraid of prosecution, the government may view your testimony as cooperation motivated by avoiding criminal consequences. That does not make your information useless. In fact, it may make it integral to the investigation, but it may not look like a clean voluntary whistleblower submission because the objective is not to obtain an award, the objective is to stay out of jail. That's why the first legal question you should ask is not how much money can I receive by blowing the whistle. The first question you should ask, and your whistleblower attorney should ask, is how do I protect myself while potentially preserving an award path? So protection is first. Always use protection, and a good whistleblower attorney will go over your protection. Here's the practical involvement ladder. Level 1, minimal involvement. You process records or follow routine instructions without even understanding the fraud. Level 2, a concerned, more conscious employee. You suspected something was wrong, but continued under pressure or direction. Level 3, knowing participant. You understood key facts, but you still helped carry out part of the scheme. Level 4, manager or approver. You signed off, supervised, certified, coded, billed, approved, or directed parts of the conduct. Level 5, planner or initiator. You helped design the fraud, launch the misconduct. Level 6, obstruction. This is a big one from the eyes of the government. You destroyed evidence, altered records, lied, concealed documents, or interfered with investigators. And on all levels, I want to see how much and how often you directly benefited from the fraud. As you move up that ladder, your exposure increases. It's not a ladder you want to climb. That doesn't always eliminate whistleblower options, but makes your legal strategy critical. So what should you do? Build a timeline. Separate what you know from what you suspect. Identify who directed the conduct. Identify what documents exist. Preserve lawful evidence in your possession. Do not, and I repeat, do not destroy, alter, or hide anything. Do not lie. Do not take privileged or unauthorized documents. Don't call the regulators alone because if you have exposure, you may be the one who this is hung on. Do not assume internal reporting is safe. A lot of times they're going to blame you for the conduct and fire you. Do not wait until someone blames you first, and do not assume that participation automatically ends your option. A serious whistleblower matter is not just about reporting fraud, it's also about protecting the whistleblower. A focused whistleblower law firm should evaluate 5 things before anything is filed. Front and center, first, your exposure. Next, the correct program to file it in. Then evaluate the evidence, the disclosure strategy, and the award and cooperation issues to plot the case in its entirety. If your own conduct can be questioned, obtain advice before making the next move. The right strategy can protect you. The wrong first move can make a bad situation worse and damn you. If you have credible information about fraud but are worried you are involved, contact Brown LLC for a free confidential case evaluation before reporting, filing, or moving records or destroying anything. That may be the difference between obtaining an award or going to jail.